my name is Van Smith, managing partner here at Smith Strong, and today I'd like to talk to spouses that have been cut out of a 401k, an IRA, or another investment account. A lot of people do not realize they have relief and options when they are shocked to find out that a spouse that they were married to when they pass away has, unbeknownst to them, surprisingly, cut them out, modified the beneficiary so they no longer are a beneficiary of a 401k or an IRA or an investment or bank account. And so this happens more often than we think. And for most people, they think, well, the only remedy I have is to complain to all my friends about it. No, you have better options, legal options at your disposal. And I'd like to educate you to the process. First, your spouse must provide notice of any modification or change in beneficiary, canceling you or cutting you out of a 401k account. So there are federal laws in place to prevent that from happening in a 401k context. Interestingly, I was just interviewed by NPR earlier today on the issue of IRAs not having that requirement. And so as a result, more spouses find themselves shocked that IRAs have been modified without them knowing about it, perhaps favoring children from a first marriage, or maybe a friend or a paramour they had no clue about. And so what to do? First, you have options. Let's imagine for a moment that you've been cut out of the IRA. You may claim an elective share of the augmented estate of that deceased spouse, reclaiming what is yours, a portion of it. But there's a complicated formula. We first have to understand, number one, when the modification was made, was that person under fraud or duress? Were they with full capacity? Or was it changed by a caregiver when they had a lowered level of dementia or Alzheimer's? So it's important the timing. When was that modification made? And what was their state of mind connected with medical reports when they made that change? If we overcome that, Van, they actually never had any neurological issues, or it wasn't at that level when they made the change. In fact, they made it 5 years ago or something like that. Then we go to the next level. Okay, so you were cut out of the IRA and there's no claim of neurological issues or fraud or duress. Now we go to filing an elective share as a spouse at the time of death of their estate. Very important to do this within 6 months of the recording of that will after the person dies. So time is of the essence. Meet with one of our attorneys here at Smith Strong, and let's make sure we file this election so you get the share you're entitled to. Van, how much, you may wonder, can expect to receive from that IRA? And it will depend on a number of factors. Number one, how long were you married? Believe it or not, how long you were married will affect how much you will receive from that IRA that you've been cut out of. Also, did you receive any other assets from his or her estate? And if yes, that too will modify how much you receive. There are other elections that we can claim if you've been cut out entirely from your spouse's estate and assets. Like what? A homestead exemption. Even if your name is not on the title, we can ensure you remain in the home for at least a year or more so that you can make sure your life is stable through this process in court. Number two, you can claim up to $20,000 in personal effects or the equivalent of actual items. There's also additional allowances to give you actual dollars to keep the roof over your head and food in the refrigerator while we figure these things out. So, number one, gather information, gather medical reports, understand when the modification was made. If you have no access and don't know where to begin, don't worry. Simply call our office here at Smith Strong and schedule your first comprehensive case preparation meeting. Unfortunately, this is a reality for many clients every month here in our office, and it's one of our fastest growing practice areas, estate and fiduciary litigation. We'd be delighted to meet with you, and it'd be our honor to serve you and restore your financial stability moving forward in your life. Thank you.